if it's not in writing, it doesn't matter what y'all talked about.
Right.
You're saying we have made the entire agreement that we have between the parties is reduced to this writing. Anything else that's been discussed but isn't in this writing is like it never happened. Hey everybody, welcome back to another episode of the Real Estate Show. I'm Tiffany Weber, real estate attorney in Mooresville, North Carolina, with an office in Huntersville. And today I am joined by another attorney in our office, Megan Anderson.
Hello, hello.
Welcome back to the show.
It is good to be back.
It's a treat for me because it's like, oh, I don't have to be the only one talking about the law. Because Ryan's like, tell me the laws. And now I don't have to be the only one doing that. But we are doing kind of January focusing a lot on back to basics. So, some of the other episodes, if you've heard them already, going over the buyer's CD, the seller's CD, things like that. So today I thought it would be, maybe fun is not the word. It's fun for us.
It's fun.
Going over.
Enlightening.
It's enlightening for sure. Going over the North Carolina offer to purchase and contract from a buyer's perspective. So if you're representing a buyer, these are the things that we tend to see buyers get tripped up on a lot. Or, a lot of times we'll get questions because maybe a buyer hasn't fulfilled one of the terms in this contract and doesn't understand why that's a bad thing. So let's dive right in. The first page, I didn't really highlight anything specific to the buyer on this page because this is important to everybody. Not that there's anything in the contract that's not important to everybody, but if we're talking about the things that are going to affect a buyer significantly, or they should be acutely aware of, especially if they're from another state, I picked up with the due diligence fee and earnest money deposit, actually delivering those. So there's a part on the second page of the offer to purchase and contract that says, should buyer fail to deliver either the due diligence fee or any initial earnest money deposit by their due dates, or those checks be dishonored, then the seller can give notice to the buyer. They've got 1 business day after that to get those funds in. And if they don't do that, the seller can terminate. And this is the kicker. Because of that buyer's failure to deliver in a timely fashion, the seller shall be entitled to the due diligence fee and earnest money deposits. So talk to me about your thoughts on that. You've probably seen, like I have, people that get cold feet and then don't deliver their due diligence fee.
Yes. I mean, you're due, once you sign the contract, they're due within at least a very short period of time.
Yeah, I think it's 5 days. The due diligence fee payable and delivered to seller on the effective date. So that one's right away, but EMD within 5 days. So it's not like you've got, an unlimited amount of time to get that stuff in.
Right. So once you sign when you're reviewing the contract, make sure you are game ready. Yeah. Because your money is going to be due. You need to get that in, because then once you sign it and all the parties have agreed to everything, then you're on the hook for that money and those deposits.
Yeah, I mean, after the effective date, which is the last date of either of the parties to sign, you're under contract. There's nothing left to happen for you to be under contract. So if you terminate after that effective date, then your due diligence fee is gone, unless the seller is breached. But we'll see people try to fail to deliver one of those things and say, I've changed my mind,
right,
and think that they just don't have, well, so what? The seller's not really harmed. It's only been 24 hours.
Right.
They could have lost other offers,
Yeah. A quick back out doesn't really solve anything once you're signed.
Yeah. I mean, it's the buyer's right to terminate if they want to, but not at no consequence.
Right. Buyers can terminate at any time, but you're going to forfeit at least your due diligence, if not your earnest money, if it's after the due diligence period.
The next thing that I thought was really interesting for buyers to pay attention to that they may not realize, on the topic of earnest money, say they've paid in their earnest money and they think, and they terminate after due diligence, they may make a claim to get their earnest money back. They might terminate and say, I want my earnest money back, and the seller says no. Well, in that case, there's now a dispute over that earnest money that's being held in escrow, most often by our office, but it could be the real estate brokerage holding it in their trust account. And that puts us in a unique position because we have to step back and say, we can't be involved in this anymore. Each of you have to seek independent counsel. Even though we're engaged by the buyer at this point, you've made us a witness to this.
Right.
So you got to go get your own attorney and fight about it. Then we got to involve the court. Have you had to do any of those where, like, I don't know, since you've been with us, I don't know that we've had any.
I haven't had any. I've previously, I've only gone to a certain extent, and after each party had found their own counsel, and all the facts were laid out, everything was reviewed, then they came to a agreement. I think they returned half of the earnest money, just to make everybody happy. But it didn't go to litigation, didn't go any further than that. I didn't have to stand on the witness stand.
Well, thank goodness.
So, but yeah, I mean, they came to an agreement, which, I mean, rightfully so.
That's preferable than the special proceeding. And it's laid out right here in the contract. So I certainly don't expect agents to have like an encyclopedic knowledge of everything in the contract, but a lot of agents that have been doing this a long time, I'm always surprised when they are surprised by this because it's got that black box around it. It's like one of those things that, the Real Estate Commission and the Bar Association are like, hey, this is a thing. Whoever's holding that earnest money is going to have to pay it into the clerk, and you guys are going to have to litigate over it if you can't agree. So I like to call attention to that. Now,
more than the black box already is around it.
Yeah. Which, I mean, pretty good idea. If something has a black box around it, that it's probably something you should really, really pay attention to.
The notes are there to help you understand and know what might happen in the future if certain events take place.
This is your roadmap. So you don't have to guess. It's telling you what's going to happen. The next thing that I highlighted here was the due diligence fee, specifically that it's non-refundable except in the event of a material breach of the contract by seller. We talk about this topic quite a lot, but could you dig in a little bit to when can you get your due diligence fee back? And I think that's especially useful for the out-of-state buyers.
So your due diligence returning to the buyer would only be possible if the seller was in breach or, something didn't match up to what you are purchasing, what the seller disclosed, or if they don't disclose a pertinent material fact, or if if agents know that you're buying a property for a certain specific reason and they withhold information. Those type of things are, material facts to the contract, which would allow you to have due diligence returned, but they're very few in, this large scheme of the real estate transaction. Yeah.
The answer to that is almost never, except for those things that you described, which are rare. Thank goodness.
Very rare.
I mean, it's a good thing that sellers don't go around breaching the contract every single day.
Yes.
I'm sure that across the entire state, I'm sure there's a breach every day. But in our local market, thankfully, it's not just sellers breaching willy-nilly everywhere. So in that case, we rarely see a return of the due diligence fee or see a buyer that's entitled to it. And even if they are, if the seller doesn't cough it up willingly, they got to sue to get it.
Yes.
That's another thing I think might be misunderstood, especially by out-of-state buyers, but even in-state buyers familiar with the due diligence fee, is that it's paid to seller. Seller's supposed to deposit that, and
it's in their account,
and they can spend it because it's theirs. So if you try to claim you're entitled to it back, if they're not going to write you a check back, they're probably not.
If they're not compliant,
then the only way to get it back is to sue. And we'll get questions from buyers like, well, what's my other option?
There is
negotiate.
None.
I mean, if they won't negotiate, that's your option. The next thing that I wanted to highlight is in the contract, the contract's very careful to define settlement and closing differently. So a lot of times people come to our office, they sit at the table, they sign, and they think they're done. So if I had to guess, I know what you tell them at the table. It's probably the same thing I tell them. When people are like, okay, we're done now, right?
Can I have my money?
Yeah, can I have my money? What do you tell them?
So once everybody has signed, if they're all at the same table and we have all the funds, so we have to wait till we have all the money from the lender or buyer, if they're sending in money or gift funds. Everybody has to sign everything, has to be notarized. And then we have to take it to the county, get it to the county some way, somehow. Have to have an update on making sure nothing has been filed since we originally checked for the title search. And then once everything is clear on that end, the county records it. And then once we get it back from the county, then everything will be processed out. Then the money is dispersed. You know, it's always there are certain time frames for it takes as long as the county takes, and sometimes they are slow. And then once we get it back, depending on how many disbursements are in line ahead of you, you know, I give them a little bit, you know, there's been a couple hours between when it's recorded and when we can disperse, but they have to wait.
Yeah, it's not instant. Like e-recording, people will think, well, just e-record it and say, well, if you just go e-record it real quick, that's a digital line, just like a standing in person line. The only thing we don't have to do is drive. So,
Right.
You know, we might save a few spots by not having to drive there, but you're still standing in line.
Yep, you still get in line when, you know,
There's
if
still
somebody else is
manually
e-recording
looking.
ahead of you, you still have to wait for that other person to, you know, get everything through. And you still have to wait for the county to respond and send you the recorded document.
I know. And
Time-stamped.
another thing is, if for some reason there's an error electronically, they just reject it and then you have to get back in line. It's not like you get to hold your place. If you're standing there to record it and they're like, oh, you're missing a comma here. And it could be something as simple as missing a comma. You just fix that thing and you don't
Right.
have to go back to the end of the line.
Right.
So there can be advantages to not e-recording, but that, you know, digress a little bit. I think you just gave a really simple explanation of the definition of closing, because people will think that the settlement is the closing because they say we're going to closing. The contract calls that the settlement. The actual signing, delivering the papers. If you're a mail away, it's the delivery of the signed documents to our office. That's the settlement. And then the closing is when settlement has happened, the title update is satisfactory, the closing attorney has gotten authorization to disperse all the funds, meaning we've got the funds too, and then the documents being recorded. And then, and only then, can the proceeds be dispersed. So I think that's an important thing to clarify is settlement and closing have very different meanings. Settlement is part of closing, but it
Yes.
is not the end of the closing.
Yes, the closing is the close of your file, that everything is said and done.
Yeah.
Settlement is when everyone has signed and we are ready to continue on with the
Yeah. The signing of the
admin part.
paperwork is just the, it's not the first part of our process. We do way more stuff than that. And we've been working on the file for quite a while by the time you sign. But when we're getting to like the nitty gritty, that's the thing that kicks off the
Yes.
flow of things.
That's the excitement.
Yeah, exactly. So moving on to more things for the buyer, I kind of like to jump to paragraph 4. It's on page 5 of the offer to purchase, and it's talking about buyer's due diligence process. So earlier in the contract, a due diligence period is defined, and it is time is of the essence, meaning that date is not flexible. It is what it is. If you blow the date, you too bad.
Right.
So there's quite a few black boxes here. And it even says warning, not just note. It says warning. Buyers strongly encouraged to conduct due diligence during the due diligence period. You can continue conducting due diligence after the due diligence period, but after that period has expired, you will lose your due diligence fee. So this whole warning is about do your due diligence during that period so that you can protect, or excuse me, I said due diligence fee. I meant you're going to lose your earnest money deposit. You've already lost your due diligence fee. So getting all of that process done prior to the due diligence period expiring protects your earnest money so you can get it back. So here in all caps, we've got a black box, warning, and multiple instances of all caps. So,
And bold.
And bold. So buyers should terminate prior to the expiration of the due diligence period unless you can obtain a written extension. And then it says in all caps, seller is not obligated to grant an extension. This is a question we get a lot. Not just this, but then also the negotiating, which we'll talk about in a little bit. But the seller doesn't have to say. So what does a buyer do if the buyer wants more time for due diligence and the seller says no?
Well, they can try to negotiate. Yeah. Most of the time, if the seller is unwilling to negotiate the due diligence time frame, you can amend it to put in more money to extend it, basically another due diligence period, but you've kind of forfeited that first due diligence.
Yeah, like you're buying more time, just
right.
Increasing your due diligence fee to get more time.
Yeah, and that might be worth it depending on how much earnest money you have put down and what type of, I don't want to call them complications, but type of issues that are found or you think might be going on with the house or the property. But other than that, due diligence, it's on the buyer to make sure you schedule everything right when you sign your contract. Schedule those inspections. Schedule people to come out if you think something's going on. Look up the permits with the county, the setback. We had the restrictions. Look, it is on you to, that's what your agent is there for, to make sure everything that you are wanting to do with the property falls in place and is allowed. We had one a couple weeks ago that the addition they wanted to put onto the house did not fall under the new guidelines of the county. It was a county requirement. Had nothing to do with the seller or the seller's disclosures. But it was the county that said, no, you can't do that. And the buyer lost. They were going to forfeit their earnest money and due diligence.
Yeah, because that's a thing that, like, the seller hasn't breached anything. There's nothing to disclose. They haven't violated anything. So if you don't inspect that, then you could end up buying a property that, you can't do the thing that you want to do with. And ultimately, if the seller won't grant an extension, then if you don't want to risk losing your earnest money, you got to terminate.
Right.
So it might mean that because you didn't plan or didn't give yourself enough due diligence time. That's another thing. People will be like, oh, I'll only do 7 days due diligence because I'm trying to negotiate aggressively. It is near impossible. I'm not saying impossible, but near impossible to get all the inspections done you need in that time frame. So if you're trying to bet on the seller giving you more time because they're under contract and you're hoping they'll be nice, they don't have to. And it's in all caps in the warning box. So this is one thing that if you've got a surprise buyer because of this, they shouldn't be. This is, make sure that they really understand this. The other thing, next box warning, this one's just a note, not a warning, but under 4A, under the loan, there is no loan or appraisal contingency in this offer to purchase and contract. It is less so now, but I'd say probably the past year or two it's gotten less. But I used to get a ton of questions of like, well, they have to give me my earnest money back. I couldn't get approved for the loan. Do you get those questions too?
Yes. So I know when the market was super high and everybody was selling, for $100,000 over the value of the property, loans were, getting more stringent.
Yeah. Appraisals not coming in.
A lot of appraisals did not come in. People were having to take out, lines of equity to like cover the difference on the property from other properties or, gift funds. But yeah, so if and the other option would be to put in a contingency in an addendum to the contract if that is something that you haven't already worked out. If you haven't already been approved for a such and such amount for a loan, you can put in there a contingency if that you don't get approved, but that has to be disclosed up front to the seller and a part of the contract all together in one.
Yeah, and I don't even think there's a standard contingency addendum anymore. If I remember correctly, that was done away with. So that's an attorney drafted form. That's not something that you can just write in because there's way more than you could, unless you are an attorney or a party to a contract can draft their own contract. But if it's an agent, you can't write that in. Yeah. So that's got to be an attorney drafted addendum. So if you are operating under the assumption, or if you have a buyer that's operating under the assumption that if they don't get approved for the loan, then they just get all their money back, they are wrong. And that can be devastating. Yes. Because, that might be, that might have been all the money they had.
Right.
And then the other thing is, I know agents know this, but encouraging buyers that there are lenders that you can get through underwriting before you're even presenting an offer. The pre-approval letters are awesome, but there are lenders that will underwrite so you know for sure that you've been approved.
Yes.
You can do your own research on who those are, but we work with one that does a ton of volume in this area, and they can get you through that process so that you can confidently say, I know, I got this. I'm going to get a loan, and I already have what I need from the lender, and we'll be rolling. So if you've got a buyer that is thinking that it might be dicey, it could be worth it to go with a lender that can give you that confidence before you're even under contract. Because if they can't get approved, depending on the timing, we know they've lost their due diligence. But if they find out after due diligence has expired that they can't get approved, they've also lost their earnest money. And if the seller hasn't breached anything, and it's just because they couldn't get approved, then they're done. That's a heartbreaker too.
Yes,
because it's just a common misconception.
I feel like that happens a lot more with clients who are on a tighter budget, who don't have a lot of extra funds just sitting around. That they do want to put in to make a aggressive offer. They put in a lot of deposit money, but then they haven't lined up all their ducks with with the lender side. And I think that
or they get a gift that hasn't been sourced properly. Right. Maybe parents want to be nice and say like, oh, you just got married as a gift. Here's your down payment. But that has to be sourced and approved by a lender. Or maybe we see this with like entrepreneurs a lot. If they get paid in ways that, the self-employment, they haven't been doing it long enough, could cause an issue. It's tough.
Yes.
So you got to be super careful when you're not sure that you're going to get approved for the loan to protect those deposits, because otherwise you wasted time and money and then still don't have a house.
What would you say would be the first step of buying a house?
To me, if I need to borrow money for it, it's to figure out what a lender will approve me for at what rate. I'm doing that before I'm looking at houses, because if it's going to push me out of my budget, if I'm looking, what I think I want is not something that I can afford getting a loan, then we're wasting time going to see those houses. If I have to borrow money to buy the house, that's the first call I'm making before I even find an agent. And that's personal preference. You don't have to know a lender before you start looking for a house.
Right,
agents have those contacts. Yeah.
It's not a requirement, but definitely
and if you have an agent you trust, guarantee they have a good lender that they work with that they can refer to. But in the business that we are in, we have all those contacts. So I would skip that step and just call the lender myself and then call my agent and be like, hey, this is what I can get. Let's go see these houses.
Hey, I already have a house picked out here.
Yeah, we've done that before. So the next thing on the next page would be 4D, repair improvement negotiations. So this one is in all caps. The property's being sold in its current condition. Seller may, but is not required to, engage in negotiations for repairs, improvements to the property. Tell me about your experience with this, because I know that you've dealt with it too.
Yes. And even in new construction, this issue arises because the expectation versus the reality doesn't align in, 90% of the time. So, you walk through a house, at least you have some type of overview of what you are getting. With the inspections and everything that comes back, there might be more issues that arise. But if the seller is not willing to negotiate, and one, you have to take the house as is, because that's not, unless you're willing to, give up your due diligence and earnest money, because that's not, as long as it's past the due diligence time frame, you won't get those returned. And that is a big upset to some buyers. Some buyers don't, it is what it is. We'll take it. We'll fix it. We'll get it repaired. No issue. But some buyers who are also on that tighter budget, they expect that the issues are supposed to be resolved by the seller. At that point, I would first negotiate, say, hey, see if they would, at least if they don't want to fix it before closing, at least give you a seller credit, some type of monetary value, hopefully that will cover what the repairs might cost or what it might entail. Some sellers might counter offer with like an escrow holding of a certain amount of funds, and then whatever the actual repair costs are, they pay that out, and then the remainder will be returned to them on top of whatever they received at the closing. But if your seller is a hard no on repairs, you either take it or leave it. And depending on where you are at in the process, hopefully it's before due diligence has expired, and then you're making that tough choice of, can you fork out the money to repair it? If, is it really needing repaired, or is it just small items? Can you repair it? Time frame on that. If, moving in time frame, if you're going to get it repaired before then, there's all those considerations to make, but hopefully you're making them before due diligence is up.
Yeah, it's going to be really tough to negotiate repairs if due diligence expires today at 5 p.m. and you send it the same day. The seller might say, no, or not respond because they don't have to,
hear nothing.
They don't have to do any of this. And I think some of this is shaped by the guidance they're getting from other people in their lives. We see it a lot with first-time home buyers whose parents are heavily involved. They may have bought at a time where the market was such that sellers, they were in a tough spot.
Yeah.
If they wanted to sell, they had to make all these repairs, because otherwise they'd walk and they wouldn't have a buyer. But we've also had the opposite in recent years where I'm not doing a thing. If you don't like it, move on, because I got 8 buyers behind you that will buy it just like it is.
Right.
So the market has a lot to do with whether a seller is willing to negotiate. But I think there's another misconception of buyers, and also depending on who they're getting advice from, that the inspection report is a things the seller did wrong list, and that they should be, that if they don't fix it, it's a breach of contract. It's not correct. There's certainly scenarios where something comes up on an inspection report that a seller knew about and didn't disclose. That's a completely different issue. But if we're just talking about your typical inspection report, and this is stuff that happens over time owning a house.
Yeah, just wear and tear on the house.
Yeah, or things that seller might not even know. I mean, there's probably stuff wrong with my house right now I wouldn't have the slightest idea about. I'm not going up in the attic. I'm not looking at all that stuff. Like, it's not stuff that's like, and even buyers who already own a home, are you walking up in your you doing a...
Only when I'm fixing stuff that I know is broken.
Right. And the other thing, too, is the inspector's job is to be incredibly thorough. Not everything is dire. A lot of this stuff is, like, extremely normal when you have a house that's not new construction. Sometimes it's normal in new construction, depending on what it is. And the inspector's job is to tell you everything so that they don't get sued by you. So,
Right.
People will be like, that inspection report was 80 pages long. Yeah. And 60 pages are huge pictures.
Yes.
If we were to just still down the actual text on it, it's not that long. And then also your inspector is most likely to tell you the critical things too.
Yes.
Like these are big things that you need to address.
Yeah.
These things are lower priority.
You probably have a list of, 15, 20 things that they suggest that you either fix or repair, but then you have a list of like 2 or 3, maybe 4 items that maybe will make or break the deal.
Yeah. Yeah. And when it comes to negotiating, like agents explaining to their buyer that not everything on that list, like maybe you don't present all of that because you could send a seller like, get out of here with that. I don't know. I guess it depends on what seller you're negotiating with. But from my perspective as a buyer walking into a deal, and that's because I read these a lot, and I'm sure you do the same thing. I walk into a deal assuming not a thing is going to be fixed. Mm-hmm. If I can negotiate for something to be fixed, awesome. But knowing going in that the seller does not have to do a thing really helps level set. Like, do I actually want this? Do I want to put any money on the line? Just from what I can see. Now, the next thing we already talked about a little bit, but buyer's right to terminate. While the seller can't terminate, except for buyer breach in some limited circumstances, this is kind of like North Carolina's at-will employment, where you can fire somebody at any time for any reason or no reason at all, just not an illegal reason.
Any reason, no reason, doesn't matter.
Yeah, so buyers can terminate for any reason or no reason just by sending notice, and that's all that's necessary. And if it's prior to the due diligence period expiring, the earnest money being refunded to buyer. Now, this is one that I want you to talk about. Closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing. I know you've got the closing table stories like I've heard of, we just did the walkthrough and there was this blah, 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 blah. I'm like, okay, well, when are we going to reschedule this for? And they're like, oh, we're not. We're going to close it and we'll just have them fix it after. What do you think about that?
When they say, oh, we're going to do it after, or, oh, we're going to talk about that later. I was like, did you get it in writing? Mm-hmm. Is it in writing? Because once everything is signed and the deed has been recorded and it's in your name, you are the owner, and the prior owner does not have to do anything going forward with that property. Mm-hmm. So any provisions or addendums, side deals, make sure that it is in writing. Everyone has signed it. Mm-hmm. Everyone has a copy of it. And everything is detailed out. Because if you don't have the details in there, then it's a wishy-washy. Yeah. Whitewash.
Good luck trying to enforce an oral agreement.
Right.
That's probably not even really agreement. Yeah, I mean, if you say we're going to do it after, or they told me they would fix it, well, if it's not in writing, by the act of closing, if you close, then you have accepted. You're saying, I'm cool with it how it is. We can move on. Which is a big risk.
A lot of those come with like family deals or like good friendship deals. And I love my friends and I love my family, but just past experiences of not going the way I wanted them to go, or, the expectation was not there, that, not up to my standards, we do it in writing. Yeah. Doesn't matter who it is on my end, we're going to get it in writing and you're going to sign it. We're going to date it. Yeah. If we need to notarize it, we can, but have everything, at least in some written form, email. That way everybody knows what is expected. Yeah, because otherwise you're out of luck. There's, and not to get too nerdy on this, but, and I wasn't going to talk about this provision, but there is a clause in the contract at the end that's kind of like the miscellaneous stuff that's like entire agreement. And we've got law school words we could use to talk about this, but basically the point of it is
if it's not in writing, it doesn't matter what y'all talked about.
Right.
You're saying we have made the entire agreement that we have between the parties is reduced to this writing. Anything else that's been discussed but isn't in this writing is like it never happened. So there's multiple times in this contract it says if it's not in writing, good luck.
There more than I would like to count. There have been times at the closing table, buyer has said something, well, this and that are supposed to stay with the house, or, they're going to put in a new well or something. And
you're like, where?
Exactly. I said, where is this? It's not a line item on our statement. Who's paying for it? Well, the seller's going to pay for it. Can I see that email? Can I see that agreement? Oh no, we just went through it with our walkthrough, yesterday. At that point, I say, that after you've signed it, you are said and done, and they don't have to do anything. Well, they agreed to. They agreed verbally, and unfortunately, those verbal agreements are not enough for that issue.
Yeah, it's heartbreaking when people they'll think, I've got it settled. I don't even need to bring it up at the closing. So they call us after. They told us verbally when we walked through that they would do this, and we're like, if we don't know about it, we can't advise you. Especially since it's in the contract that you signed from the very beginning. Now, on the topic of like fixes or due diligence, jumping ahead, it's on page 10. I think it's section 8C. Is that right? Yeah, 8C, seller obligations, access to property. Seller has to provide reasonable access to the property through the earlier of closing or possession by buyer. It says closing or possession because seller can choose to deliver possession to buyer earlier to closing. They don't have to, but if they do so by buyer possession or by turning over the keys to the buyer prior to closing at their own choice, that's why it says or. But this provide reasonable access to the property, some buyers will think that they can go by every day. Oh, I need to get in to measure. And then the day after that, I need to get in to look at some paint samples or, and then my inspectors come in the day after that, and then this and that. At a certain point, that's going to become unreasonable. So if you've got a 45-day closing window and you need access to the property 25 times, that's likely unreasonable. Like you could have consolidated those visits.
No one is going to say that's a reasonable, inconvenient time for the seller.
I mean, it's like if you stack up all of those appointments, and especially if the seller's still living there, and they got to get kids and dogs and, at a moment's notice because you forgot to measure the windows for your curtains when you already had an appointment, be considerate of that. But on the flip side, the seller can't deny you reasonable access. So if you have an inspection that you need to get done, the seller can't say, no, you can't have that inspection. Now, they might say, no, you can't do that inspection at 2 a.m.
Right.
You got to be reasonable about it. But again, they can't say you can't come. And then the other thing that we see a lot is buyers will say, we went to do the walkthrough, but the utilities were off.
I've had a lot of that lately.
Seller's obligation includes providing existing utilities operating at seller's cost, including any connections and dewinterizing. So if you turn off your utilities before buyer gets possession, then yeah, you're going to have to pay to turn them back on if they charge you a fee to get them back on, because it's your obligation. And this is, of course, unless they agreed otherwise in writing, but assuming that they're just operating by this and didn't alter this term, then the seller's got to keep the utilities on at their expense.
So circling back to that, I had a closing, it's been a while, but the sellers didn't live in state and they had turned everything off, thinking that they were done with their part. And at the final walkthrough, the buyer realized that she hadn't tested the water pressure. So, but she couldn't test the water pressure because the water was off. And she had asked me, you know, is this a breach on the seller side? Is this a breach of contract? I said we were at the closing table. I said, you're here to close. You know, if that were a material breach, yes. I said, that's normally not a material breach because they can be turned back on, you know, within 24 hours.
Yeah.
So the seller
so when we get into refusal or, you know,
right.
egregious beyond like a mistake, that's one thing. Yeah, they'll have to turn it back on. And if they say they're not going to, then we might be looking at breach. But in general, you know, mistakes do happen.
Yes. And it was, you know, just they didn't live here. They didn't, they thought that the closing was, you know, I think they turned it off the day before just because they had closed out the house, like closing up, had taken everything out and were done. And then they just didn't think the final walkthrough was going to take place. But I mean, the buyer still showed up to closing. So it wasn't like she was really going to proceed with that. But, you know, if the seller hadn't agreed to turn it back on, but I think she was getting them turned over into her name anyway. So
yeah. Well, then there's also, depending on the utility company, the buyer initiating the call to get the utility switched could turn them off in the seller's name.
Yes.
So it just depends on the company. Now, you mentioned something, material breach. That leads me into the next thing on good title, legal access. So the seller has to deliver clear title. We've done a ton of episodes on that, so I won't get too deep into it. But there is a change to the 2023 version of the contract that's important. The title has to be free and clear of any issues that would materially affect the value of the property. That used to just say free and clear of any encumbrances. So if we're looking at a strict interpretation, a 2-inch fence encroachment is a violation or is an encumbrance. But now this materially affect the value of the property language, buyers may not realize, oh, well, let's be serious. Does a 2-inch fence encroachment materially affect the value of the property? In almost all cases, no.
Right.
We have to look at the facts of the particular closing, but generally speaking, no, it's not going to. So that's not going to be a seller breach for things like that. Right. So I just wanted to call attention to that. Now, the negotiated repairs and improvements on the next page, section N, if the seller agrees to negotiate improvements, they've got to be in a good and workmanlike manner, which has a definition in the North Carolina common law, and buyer shall have the right to verify same prior to settlement. Have you ever seen the situation where seller has said they've made repairs, but they won't let the buyer back in after the walkthrough to see?
I have not come across that, but that's very interesting that the buyer wasn't able to verify.
Yeah, so it was kind of this combination of, one, they're violating the fact that the buyer gets the right to verify before they have to close. In fact, before they even have to sign, because it says that's settlement, not closing. So if you haven't let them back in to verify it, they don't even have to show up to the attorney's office to sign their paperwork until you've done that. But then the other side of it is the reasonable access we just talked about.
Yes.
You know, like they said, yeah, you can't come in the house. Well, if they're there to perform, you know, things to make sure that you're meeting your obligation. This particular scenario, they had not been very often. They'd kept visits very minimal, only to the necessary stuff. The seller just said, nope, out of luck. So obviously, because of the terms of the contract, the buyer was able to go back and verify. But that's something that sellers may not realize too, and buyers may think, oh gosh, if it's not done by the walkthrough that we have scheduled, I'm out of luck.
Right.
You're not. If they complete it after that scheduled walkthrough, you still have the right to verify it before you close. And then if you don't, then you close.
You're taking it as is.
Yeah. Oh gosh, we're just having too much fun with this. This is a long episode. So moving on to the owners association charges. there are some changes to what the buyer's responsible to pay for. Sometimes buyers will be surprised on the closing statement to see they have to pay like a capital contribution or
A transfer fee.
yeah. And they're like, oh, well, shouldn't the seller have to pay for that? The seller's got plenty of stuff they have to pay for. Don't worry. The seller will pay for their things they're responsible for. But under this contract, the buyer has to pay for certain HOA things. So they shouldn't be too shocked or explain to your buyers that there will be charges from the HOA most likely on their closing statement. Now, paragraph 12, delay in settlement and closing. Agents all the time think that this is an entitlement, that any party can trigger this just because they need another 7 days or because they want another 7 days. And that is not true. There's a very important phrase in here that says, this paragraph shall apply if one party is ready, willing, and able to complete settlement on the settlement date, but it is not possible for the other party to complete settlement by the settlement date. So if you're a buyer and you've got a seller who says they need another 7 days because they have, so it's inconvenient for them to close on the day that you have specified. Inconvenient is not impossible. Impossible is the seller was in an accident, or, not to be, I shouldn't have taken it so morbid right away, but there are impossibilities. But if it's just tough for you to get there, or let's say the seller thought that his wife didn't have to sign and she's in a different state, well, that's not an impossibility. That's a failure to plan.
Right.
So a seller would be in breach for that. If you create the scenario to make it so you can't close on that day, that's not an impossibility. We're looking at like external forces.
Right.
So I always like to point that out. Thankfully, I think people are starting to understand that the 7 days is not just a gimme. But we still have a lot of work to do on that.
So on the flip side, if a seller is purchasing like a new construction and they are not able to leave the house on that day because their new house is not ready because the builder hasn't gotten the certificate of occupancy, how would you say that?
Just based on those facts alone, I don't know that, would it be in a buyer's best interest to not have to sue for breach and give them some time? Yeah, it'd be less expensive probably, unless they're being charged a rate lock extension, et cetera, or they themselves don't have anywhere to go. But I think a strict interpretation of this paragraph would not say that's an impossibility.
Right. I would agree, because a seller could store their things. They could move into an Airbnb, get a hotel room for a couple days. There are, it might be an inconvenience, but it is not an impossibility.
Yeah. That's a tough one. It's a heartbreaker for everybody because it's not the seller's fault.
It's a third, but it's a third party, but you're still have to perform your contract and your conditions with your buyer. Yeah. Even though the one that you're purchasing,
even if it might not be ready.
That might have been a scenario recently.
I've seen that one myself too. They're like, well, what are we supposed to do? And I hate having to tell them, but that's what they have to do.
You have to figure it out.
Now, possession, the next paragraph, this one I like to call out for buyers, and we've touched on it a little bit, so I don't think we need to spend a ton of time on it. But possession, including all means of access to the property and transferable amenities and services. So like mailbox keys, codes, garage door openers, pool keys, etc., shall be delivered upon closing. So, and I mentioned this because, by the time by closing, we know you're entitled to possession. That's what the contract says, and it's also logical. But then we have buyers at the table that are like, well, why can't I have the keys? I have a moving truck.
Right.
So I know that we could have better education between agents and their clients on when possession is transferred. And it's not until closing unless you've got a seller that feels like being nice.
Right.
They don't have to do it. If they feel like being nice, awesome. Just thank your lucky stars and roll with it. But it's kind of tough for you to get mad at a seller to do something that they have no obligation to do.
Yes.
So tell your buyers to schedule accordingly.
Yes, that's what I was going to say. At least plan, talk about it, have that conversation. You know, do you intend to give us the keys at the table at signing, or are we going to wait until everything is recorded to take possession? Yeah,
there's nothing preventing you from having those conversations up front, and then you can manage expectations at the table, which of course is preferable to having the moving trucks and, oh, they're meeting me over there to do so-and-so. I've got flooring people coming. I'm like, well, this isn't even recording today.
Yes.
So your flooring people are not coming today. So yeah, just talk about it. Just make a plan.
Just talk about it.
Yeah. And you know what? I feel like there was a lot of good information in this episode, and I didn't think it would take very long, but there's so much in here.
Yes.
And we didn't even talk about half the stuff we could have.
No, we had some good examples, though. I feel like there's lots of, I think a good word to describe this episode would be like expectation.
Yes. Manage expectations.
Yes.
I think that the day that we're recording this, obviously it's not coming out on this day, but we posted something on social media about the best agents manage their clients' expectations. So you hit it on the head. Managing your buyers' expectations. And a good way to do that is by making them read this contract.
Yes. Before they sign it.
Before they sign it, yes. All right. Well, that wraps up the key things for the buyer. This is by no means exhaustive. We're just giving you examples that we see in real life practice. If we've said it, it's because we've encountered it. So if you're listening to this saying that doesn't happen, it has, and I hope it doesn't happen to you, but it has happened. And there's a chance that, if it comes across your desk, you're going to want to know how to deal with it. So Megan, thank you so much for your time today and for all your examples and advice. And we'll see you in the next episode.
Thank you. See you soon.